So we're not talking about nothing about time sharing. Okay, this is just child support. So you may deal with child support related to a circuit court matter. So let's say our main office is in downtown Tampa. So let's say Hillsborough County. There's circuit court cases where maybe you file a petition for paternity and time sharing and child support, and the child support's dealt with in that proceeding. So Hillsborough County also has child support actions that are just related to child support, which are heard by the hearing officers in Hillsborough County. So, and again, just this video is specifically about the different options in Hillsborough. So you may be in front of one of the hearing officers, and if you try to bring up, well, I don't have a time sharing schedule, I want to be able to see my kids, I haven't seen my kids, they're going to say, whoa, not for this proceeding, not for dependent support enforcement and child support. That would be for the circuit court. You'd have to file a petition in there. So again, it's separate. So that's one thing we really want to make sure that clients and people understand, is that these are separate proceedings, and you may have a separate time sharing case in the circuit court, and then a separate case with the Department of Revenue for dependent support enforcement for their child support cases. So you may have these two separate. So then if you modify the time sharing, then you got to go back and modify. So as you can see, there's a lot of back and forth. So sometimes we will work to try to consolidate them. Sometimes we cannot. But that is something that we can look at and look at your set of circumstances to see if we are able to consolidate them. So that way, if there's a change in time sharing or custody, then also there would be a change in child support resulting in that, and not having to go back and reopen the other case, and vice versa. So there's two different types. And then there's also administrative law proceedings. So this is a different type of proceeding than dependent support enforcement or the circuit court. It's still filed within the county, but there's not a judge assigned to it necessarily. It's an administrative law judge that will hear different cases around the state if there's an objection to the proposed administrative support order. So usually these normally will come to you, and you'll get them, and you'll see the proposed administrative support order, and they'll give you a time to object. If you do not object, then they enter the final administrative support order, and that is enforceable. And there's usually a retroactive amount that's included in there as well. So basically, the importance there is making sure that you understand that for these administrative law proceedings, they are important. This is not a piece of mail that you want to just throw in the trash with whatever other spam mail that you're getting in your mailbox these days. But they are very, very important, and you need to read through it because there's very specific time frames. And if you miss those time frames, it makes it a lot more complicated, moving forward. But we have on numerous occasions been retained for objecting to the administrative support order because something was incorrect. So sometimes if it's based upon what information provided by the other side, or they're not taking into consideration different credits for your retroactive support. So let's say that you've been separated from the child's mother for years, and you receive this paperwork and it says that you haven't paid any child support, going back the 24 months prior to filing, or basically saying, you've never paid anything for it, but you've been exercising some time, and you've been paying for things, and you've been giving the child's mother money, throughout the course of it without a court order. That's the things that we need to look at to try to see if we can prove it. First of all, it needs to be proof. Cash is a little harder to prove, but whether we can prove it, and whether that needs to be credited towards the retroactive support arrears, because that's a part of the administrative support order. It's not only the ongoing child support and that child support amount that's going to be going on, it's also the amount on a monthly basis that goes towards the retroactive support. So they're going backwards in time, stating that you should have paid this X amount of money, and we're going to pay a little bit of it each month until it's paid off. So you want to make sure that both those numbers are correct, and a lot of times we'll object because one of the numbers, if it's not correct. If it's correct, then it's correct, but if it's not correct and they're not using information that is correct, then we would object and we would ask for a hearing on it. And the administrative law judge, when they're down in whatever county that we're dealing with for these administrative support orders in your case, would have the hearing on it, and then they would render a ruling, and then that would be the final administrative support order. And there's still appellate options available to that. But again, if you don't object to begin with, then the proposed order becomes, it will then be entered as a final order. So those are the three different types of child support actions in Florida. And specifically for this video, we were looking a little bit more about the administrative support orders, because this is a little bit different, and a lot of people don't know the law on it or understand it or haven't dealt with it. So that's a little bit of information. If you have any more questions about this, feel free to give our office a call, as we've dealt with these matters a number of times. And thank you very much, and have a great day.